Joining us now to talk about Omar Khadr's legal battles, Milan Markovic. He's a teaching fellow at Temple University, and we're happy to welcome you back to our studios.
Thank you.
Omar Khadr's had a number of legal battles, as you well know, both in Canada and the United States, and today we've asked you in here because we want to understand why the courts have decided in the ways they have decided and figure out why he is where he is today. And let's start with the torture issue, which he has alleged. And here's how Colin Perkle reported on this in the Canadian press a couple of months ago. Threats of gang rape did not prompt Omar Khadr to make any self-incriminating statements, and no evidence exists that the Canadian citizen was tortured, the military judge in his Guantanamo Bay war crimes trial said in a newly released decision. In his 9-page written ruling, Colonel Patrick Parrish states that Mr. Khadr's various confessions to his interrogators are reliable and were made voluntarily. Quote, "There is no credible evidence the accused was ever tortured, even using a liberal interpretation considering the accused's age," Colonel Parrish wrote. Let's, Milan, start with Omar Khadr's side of this thing. What is the evidence, or what's the argument of the evidence that he puts forward that suggests that whatever information he gave was done so under torture?
Well, I think one of the main facts is just the circumstances. He was someone who was obviously injured in a firefight with U.S. forces. He was brought ultimately to under U.S. custody. He was receiving medical treatment, and shortly thereafter he was questioned by interrogators. And obviously, considering his age, the fact that he was not informed of his consular rights, the right to contact the Canadian consulate, he also, shortly thereafter, and this is actually the exact subject of that decision by the military judge, he was informed that detainees who did not cooperate with U.S. forces were put in prison and subject to rape by African-American men. And this is essentially what the motion by Khadr's defense team argued, that that threat essentially made any statements made later by Khadr inadmissible as a product of torture.
The judge wasn't buying?
No, the judge wasn't buying. His argument was that you have to separate this one statement from one interrogator from the other interrogations that took place. And he emphasized over and over how the other interrogators had a very good relationship with Khadr, never threatened him, and that he never seemed very concerned about his safety. The judge does make passing reference to the fact that he was interrogated in a few occasions when he was hooded, in a few occasions when he was in a stress position such that his hands were raised over his head and he was handcuffed. Obviously, he was restrained for many of these interrogations.
Would that constitute torture?
I think on quite a few definitions it would, but obviously in the U.S. there's been a long-term debate about what exactly constitutes torture. Certainly, I think many would argue that while this conduct was certainly not something you'd expect to see in a domestic situation, it was not so extreme, specifically in light of the fact that he did not seem afraid of his interrogators such that it would constitute torture.
Let me go a little further here. You know, these threats of gang rape and sleepless nights and that kind of thing. Would these kind of interrogation tactics hold up in a civilian court?
No, they certainly would not. Just to go back to the sleepless nights, I think that's a really important point here. The judge's ruling did not consider the sleepless nights, which is known in U.S. circles as the frequent flyer program, which is what many detainees were subject to. And in fact, when the Supreme Court of Canada looked at this issue, they looked at the fact that he was subject to sleep deprivation as evidence that he was tortured. But the military judge's decision does not consider the frequent flyer program. So that was not part of the ruling. Now, whether there will be separate motions based on that program put forward by the defense team of Khadr, we'll have to wait and see.
Just a little tangent here. You keep calling him Khadr and I call him Khadr. What's the difference in the pronunciation?
I think it's just largely my mother's actually from Afghanistan. That's how she pronounces it.
That's okay. So maybe we're putting a Canadian kind of expression on it, or a Canadian pronunciation on it.
I may well be putting a Canadian pronunciation on it because obviously it's a different language.
Okay, good enough. He's tried to, Omar Khadr whatever, has tried to challenge the very legality of the military commission that has been looking at his case. What has been the lawyer's argument there in terms of that whole military apparatus?
Well, this is an extremely complicated issue. I mean, the military commissions from the day one, when they were designed by the Bush administration, have been fraught with legal problems. And the Supreme Court of the United States held in a decision called Hamdan in 2006 that the military commissions were not authorized by Congress and were therefore unconstitutional. So what happened was the Bush administration had to go back and get authorization from Congress for those commissions. Even after that point, there were a lot of allegations that these commissions were not up to international standards. And Obama, when he came in, changed the commissions so that purportedly they're much more in accordance with international law standards.
Do you think they are?
There are some serious improvements. For example, the military commissions now are not only supposed to exclude evidence of torture, they're also supposed to exclude evidence that was obtained from cruel and degrading treatment of detainees.
So it's much more along the lines of what you might expect in a civilian court, for example.
Closer. There's also a better appellate structure now. Previously, under Bush, the decisions had to be appealed to a special court created only for these purposes, and only one of the judges serving on the court had to actually be a judge. There are other improvements as well. Hearsay evidence, which is generally not admissible in civilian court and certainly not in Canadian courts, was admissible under the Bush formulation as long as a judge thought it was reliable. Now the presumption is that hearsay evidence should be excluded from proceedings, which is obviously really important in a case like Khadr's when you're relying on statements by folks who may have heard things from other people. So there are some improvements, but there are also a lot of serious problems.
Well, let's get to the major bottom line, which is many people have questioned the ability of a military tribunal to give Khadr a fair and impartial trial. How independent can a military tribunal be when allegations against the military are part and parcel of the whole thing?
I think that's a very fair question. And I think the kind of an ancillary point to that is generally military commissions are used, and in fact the Supreme Court has stated this, to try violations of the laws of war. And in fact, the Obama administration claims that's what these courts are doing. But if you actually look at the charges that Khadr is faced with, these are not laws of war violations. He's charged with murder, for example, and attempted murder. Those are not violations of the laws of war. He's also charged with material support of terrorism, which is actually a criminal violation in the United States, but it is not generally considered a violation of the laws of war. So really what's happened is we have a military court that is obviously within the confines of the administration and the Pentagon, but that's also considering charges that aren't really related to military operations and the laws of war generally. So I think that is a very fair point, that there's a real competence problem here. What extent can we expect a military commission to try these charges that would be better heard in a criminal court?
Now, he has pursued, or he has tried to pursue anyways, to have appellate courts listen to his arguments in these cases. And I think the United States Supreme Court wouldn't hear him. I don't think I think the courts here refuse to hear the case as well because, well, I shouldn't say it. I'm asking you. Omar Khadr's case is a political hot potato. Do you think there's any evidence that the courts don't want to touch this because it's a political hot potato?
I think that's part of it. Obviously, this is perhaps the worst possible case for the Obama and Bush administrations. I mean, you have someone who's obviously 15 years old when he went into U.S. custody. But beyond that, in the U.S. system, there's been scores of legal challenges. A few have been accepted, many have not. So I think he's more in the victim in the U.S. system on the fact that there are many challenges to this system, and he's just one person challenging them. And it's very hard to get the Supreme Court in the United States to hear a case because they have thousands of entreaties to get them to hear cases. So I think that's sort of what happened to him. And the courts want to give time for the Obama administration to figure out the procedures for these courts. And they really haven't had a complete trial yet. And I think there's a widespread sentiment there. Let's let these courts do their job. And then if there's problems, we can address it on appeal. Obviously, we're at a very early stage of the Khadr case.
Let's look at things north of the border, because he's tried to get Canadian courts to force the federal government to take action in his case. Here's how CBC.ca portrayed it on their website. It says the Supreme Court of Canada has overturned lower court orders that the federal government must try to repatriate Toronto-born Omar Khadr from the U.S. military prison in Guantanamo Bay. However, the top court agreed Canadian officials violated Khadr's human rights and that he continues to be threatened by the effect of those violations. Let's unpack that a bit. On what basis did the lower courts agree with Khadr that the federal government should try to repatriate him to Canada?
Well, the fundamental constitutional question there was, were Khadr's rights under Section 7 of the Charter of Rights and Freedoms violated? The court held that they were. Then the only question was the idea of remedy. The remedy that Khadr's attorneys asked for was that he be asked to be repatriated. The reason they thought that anything less would be insufficient is because Canada could not have any assurances that the statements that were procured from torture with the assistance of Canadian interrogators could not be introduced in his trial because, of course, Canada has no power to prevent the United States from using these statements.
Sure.
So the only thing that would really prevent this continuing violation of his rights would be if he were brought back to Canada, and the military commission system for him were essentially a stop. So that was the reasoning of the lower court.
And the charter clause that you've just referred to says what?
It says essentially guarantees his life to liberty and security.
Security of person,
right.
right. Okay. Supreme Court of Canada argued that Khadr's rights had been violated. They agreed, rather, that Khadr's rights had been violated. They overturned the lower court's ruling, even though it was in that court's power to force the government to act. Why did they do that?
I mean, this gets into obviously a thorny area of Canadian constitutional law. I myself, while I do comparative constitutional law, I'm a U.S. trained lawyer. But from what I would say is, it seemed to me to basically come down to a question of what branch of the government, what part of the government is responsible for foreign affairs, and they were reluctant to essentially force the Harper government to do something that the courts really did not have a capacity to understand the full ramifications. It noted, for example, that it was not privy to any conversations that went on between the Harper government and the Obama government concerning Khadr. It also stated a general principle that it defers to the political branches, to the Prime Minister and his cabinet, to carry out the foreign affairs of Canada. And this is generally an area where the courts don't want to dictate to the politicians on how to act. So I think that was, they hoped to leave the discretion of how to remedy the breach and the violations of his rights under the Charter to the Harper government.
Okay. Milan, this next question I think has no objective answer. It's really very much, I'm asking for your opinion on this case. This guy was 15 when all this went down, right? Why has the fact of his young age and the fact that many people consider him to be a so-called child soldier, why has that not factored more significantly into all of the court decisions that have come down so far?
You know, that really is a mystery, and I think it's really a matter of international law, at least from my perspective. Those who have argued that he's clearly a child soldier, I think, take the view that international law in this area has developed a lot more quickly than certainly a lot of scholars believe in the United States, and certainly people in the Bush administration, and to a certain extent the Obama administration. So to give you an example, the UN Convention on the Rights of the Child states that children under 18 should not be conscripted or brought into the armed forces. There's been an optional protocol which lowers that age to 15. But the U.S. has not signed either one of those instruments. In addition, if you look at some of the international criminal tribunals, such as the Special Court for Sierra Leone, it actually had jurisdiction to try defendants who were age 15 and over. So the Bush administration referred to that and the fact that they didn't sign these conventions, that there was no international consensus on what age you had to be a child soldier.
So internationally speaking, if you do some comparison, this is a gray area that we're in here because he's 15 years old.
Right.
If he were 14, it would be much less ambiguous.
That's for sure. The one thing I would note is a lot of countries, over 120, have signed on to that protocol to the UN Convention on the Rights of the Child. So a lot of countries, clearly, the majority of countries do believe that if you're under 18, you're a victim and not a soldier, and that you should be rehabilitated and so on, and not brought on trial. The International Criminal Court, where I formerly worked, only has jurisdiction for defendants who are 18 and over. And clearly the law is moving that direction. But I do think there are some legal arguments that the Bush administration and Obama administration have made that are credible in light of some gray in this part of the law.
Milan, as always, thanks for your help on this one. Appreciate it.
Glad to be here. Thank you.